Today was something we're getting a lot of requests in the news right now, which is the Secure Act. It is something that I talked about, I think it was the beginning of the year in one of the Kevin's Corners where I talked about reasons and what to look for in your estate plan and how to change it. And now the Secure Act has been passed and the bar has kind of had a chance to look at it, get a little bit more detail. We have some more specific things to look at. So what I wanted to talk about today was both kind of what the Secure Act is, at least as it relates to your estate plan, kind of why it happened the way that it did, or at least why they did this, and then also what to specifically look for and who it's going to affect as far as the estate plans are related. Okay. Now, I do want to say that because this is one of the major changes that's happened in estate planning, certainly as far as the retirement aspect in the marriage between estate planning has gone in quite some time. We, as a firm, are going to have certainly more information out there about this than just this Kevin's Corner. We'll have a blog up soon about it. We're going to be circulating some other materials in the very near future, so definitely keep looking for those. I just want to touch a couple of the issue spotter issues today so you know what you'll be looking for. Okay, so first let's start with what it is. It was essentially a tax generating act that was passed at the very end of last year that does a slew of things, a couple of which are things such as the required minimum distribution age, the RMD for retirement plans, from 70 and a half to 72. Basically, it pushed off for retirement. People who didn't want to take it that quickly because they were still working or whatever, just didn't need it, they could push it back, let it keep growing tax deferred a little bit longer. Good for the retiree. Where the IRS, this is really why it happened, where the IRS is going to make their money back is by getting distributions after death to the beneficiaries to pay out faster. Okay, so here's essentially the way it worked. In the past, and this is going to be the Cliff Notes version again, with the exception of a spouse, if you left a death benefit to a person, let's say hypothetically a child, it's where it usually applied, that person would have the opportunity in most plans to elect stretch treatment. They could take out that death benefit over their own life expectancies, which was great because if it was a tax deferred vehicle and it had $100,000 in it and they were much younger than the person who passed away, they only had to take out a small amount and it kept growing with no real tax consequence until the money came out. So people would set it up so that they could grow that retirement as long as possible and that maximized the amount of money you give to the beneficiary. A lot of people, and not just gave it to individuals, but they would name a trust, the beneficiary of their retirement plan. That would be called a conduit trust. And what that meant was it was a trust that was eligible to be treated like the individual beneficiary and get that same stretch treatment, okay? And what the Secure Act has done is change that for most people. So instead of getting upon the life expectancy of the beneficiary, in most cases you have up to 10 years to take it away. So let's walk through an example. Let's say I have a beneficiary who's a child who's 30 years old at the time that I pass away. So I pass away, they're the named beneficiary. They have 10 years to take that money out. They could take it all in year one. They could take it out equally over those 10 years. They could take it all out in year 9, but as long as they've taken it all out by year 10, it meets the Secure Act code. But what it does is if they could have taken out under their RMDs and life expectancy, they could have stretched that out well past the 10 years till they were 40. They could have gone well into their 80s, 90s, or whatever it would have been. So that's why it affects us. So with that, it means the distributions get paid out much quicker. So the IRS gets paid much quicker. They get paid when distributions come out. And it led to how the estate plans have to change. So here's a couple things you should be looking at. If the spouse is the beneficiary, that really hasn't meaningfully changed. You can still do the spouse beneficiary as though it was an RMD or their life expectancy. There are some other exceptions to the rule where if you have, say, a chronically ill or disabled beneficiary, they too only have to take it out based upon their life expectancy. They don't have the 10-year rule. That may or may not be good, however, because let's say they're on government benefits, collecting even the RMD might kick them off, so I'm not so sure that's a win, but for some people it certainly will be. And then also there's a couple other exemptions. Minor children, they don't have to take it out in those 10 years, especially if they're, say, 6 when they would be receiving it. But what it does mean is once they hit the age of majority, when they're an adult, 18 in Texas, then that 10-year does start to apply to them. So if they're 6 when you pass away and leave it to them, they don't have to start taking the money out. They can stretch, but when they get to 18 is when their 10-year clock starts. Okay, and then there's a few other exceptions. One, interestingly enough, that is for certain individuals who are not spouse, not essentially in the family, but also are less than 10 years apart from the decedent's age to their age. They too don't have to take another 10 years, which probably makes sense, right? So those are the people it doesn't apply to. Who is this mostly going to affect? If you have an estate plan where you left everything to your spouse and then to your kids, especially if you have a trust for the benefit of those kids, as many clients do, you probably had those trusts set up to be conduit trusts, to stretch out those payments. Now, if the stretch is not going to be eligible for them anyway, you're not necessarily losing anything, but you have better options to focus on asset protection and to focus on the creditor protection for that beneficiary, since there's really no tax benefit to look at in the future. So I feel like I said a lot there in a fairly short amount of time, which is why, especially as this is all coming out, you want to look for the other resources, the blog articles, the other resources we'll be coming out with soon. But as a takeaway point, that's one of the main things you should look at. If you're going to leave it to somebody who's not exempt from that 10-year, which is almost always going to be a child, a niece or nephew, a grandkid potentially, a lot of the standard beneficiaries that you would have, they're going to have to take it out in that 10 years. You want to take a look at your estate plan, see how that plugs in, see how it's going to affect the taxes of what you leave them, and look at how things are set up for them. You might have a trust that was designed to get a very good tax benefit that is no longer there, which means you have better options available to you in the estate plan. So like I said, that is the Cliff Notes version. Look for the other materials that come out. If you have any questions, by all means contact our office. We're going to probably be doing a lot of reviews of these plans for this issue in the near future. So you can get a hold of us through our website, galliganmanning.com. You can also send any questions through our Facebook page and we'll get them there. So with this, I just want to say thank you very much, and I look forward to seeing you all again next Thursday on Kevin's Corner.